Hi, Cyber Class. It's Professor Opterbeck. It was great to see all of you on Saturday at the summit. I hope you enjoyed it. I really enjoyed especially having speakers on different continents be able to join us and give us some perspectives from around the world. As I mentioned at the summit, we're now thoroughly into the part of the class where we're talking about compliance. And you'll see the materials this week are laying out some of the legal background in cybersecurity compliance, which, as you already know from our class so far, is really kind of a patchwork, as is privacy compliance in the United States. And we'll also begin talking about some tools and some ways of measuring cybersecurity compliance, including the NIST framework, and then in subsequent weeks, some ways of qualitative and quantitative assessment and the way that we do tabletops in the cybersecurity field. So this week you're going to be looking at some materials that are a little bit technical, but I hope not too technical. You don't need to be a computer scientist, but you do need to have a feel for how computer networking operates, for how we think about the different layers in a computer network, and some of the vulnerabilities that relate to each layer and some of the security protocols that can relate to each layer. And then some just basic principles of networking and some basic principles of security. So you have a few videos on that that I hope you get a little bit of good background out of. I also gave you to read a paper of mine that I'm working on. It's a draft. Please don't kind of circulate it widely. I'm hoping to work some more on it over the summer. But it's an empirical study of the results of settlements in data breach class action cases. And what I want you to think about when you're looking at this paper is what I'm asking in the discussion forum, which is, can we conceive of a concept of reasonable care in cybersecurity, number one, and number two, is civil litigation, tort, and other kinds of litigation that tends to get aggregated in class actions, does it provide any kind of effective deterrent or any kind of effective means of helping to regulate and police, in a sense, cybersecurity? Now, of course, that can't be the only way that we do this. The question is, does it provide at least some impetus? And I'll share with you just here. I mean, I think to some extent it does. And, I think to some extent it doesn't. Part of that is just the way the tort system and mass torts work in general. Some of that I think is unique to cybersecurity in the sense that I actually think it's very difficult to frame a concept of reasonable care very broadly in cyberspace. Now, there are obviously some things you'll see in these videos that, if you don't have a firewall and it's not configured, you've obviously been negligent. But when you kind of get beyond that, what does something like the hand balancing test mean in cyberspace? And then a little step beyond that, when we're thinking about class actions as often the mechanism in large-scale compliance, something that spurs compliance, given the way these settlements have gone, and you should know that a lot of cases, most cases that have been filed have not reached the stage of settlement. Some were dismissed on standing grounds because as the plaintiff in many of these cases, you're trying to show that you've had credit card information compromised and your card company is going to reimburse you for that. So some courts have found they lack standing. And other cases are just going on and have gotten past the motion to dismiss, but they're still in discovery and they may or may not eventually result in a settlement. But there are a number of issues, I touch on some of them structurally about class action settlements in that paper, and then specifically about the kinds of remedies that are afforded. So think about that, play with it a little bit this week, have fun with it, and I will see you online.